because former Prime Minister Netanyahu will be arriving here to take this stage from us at exactly 4 o'clock, I understand. I will attempt to be brief in my opening remarks. I will present to you all the speakers at once, and then they will come up to their stage in turn after I present them. First, I have to apologize for one change from the program. If you notice, there were originally going to be 4 guests on today's panel. Professor Eugene Kontorovich of Northwestern University could not appear. He unfortunately has a herniated disc and is taking care of that right now in Chicago. In his honor, so that he can follow what I'm saying on the web broadcast, I'm speaking in English right now. Now, as I'm an academic and I feel that everything I have to say is extremely important, I'm going to not abbreviate my remarks and just speak really quickly. No, I will try to keep them to a minimum so that I can turn over the stage to our guests. Let me just give you a very brief explanation of what this panel is intended to be about. I have to say that this is was a difficult topic for me to get my mind around. The legal questions of legitimacy of the State of Israel, for the simple reason that there is no such legal question. There is no such thing in international law as an illegitimate state. There are only states and not states. If an entity has people, a territory, government, the capacity to carry on foreign relations, according to some, if it's recognized, according to some, if it declares itself as such, if it has these ingredients, it's a state. Israel has these ingredients, therefore it is a state. End of question, nothing interesting to say. So we should go home. Now, there are some interesting historical questions, how it came to be that Israel developed all these ingredients, and we spoke about that in the last panel. We heard some of the discussion of the history of the State of Israel and the development of its borders, but we should understand that aside from the question of its borders, this history is largely irrelevant. Most states were not preceded by a General Assembly or other UN vote endorsing its creation. If the General Assembly had not voted in 1947 to recommend dividing the Mandate of Palestine into Jewish and Arab states, that would have been completely irrelevant, so long as the entity that resulted had people, a territory, a government, the capacity to carry on foreign relations. It would be a state, which the State of Israel is. I might add that given that by its terms it was only a recommendation, I'm not sure how much binding legal relevance it has anyway today. It's also true, historically, that if the League of Nations had not entrusted Britain in 1922 with the Mandate of Palestine, charging it with the creation of a homeland for the Jewish people, that it is very likely that we would not have a Jewish state today. And while this is, again, important for the question of borders, it's not important for the question of whether there is a State of Israel. Today, again, Israel has the legal requirements of a state, therefore it is a state, irrespective of the history that preceded its creation. So the real legal questions are not questions of the legitimacy of the existence of Israel. The real legal questions that have to be treated, or that can sensibly be treated under international law, are questions of behavior and treatment. That is, are certain actions carried out by Israel and by other states legal under international law? And is the way Israel is treated by other states legal under international law? Now, we have to understand that because there are no categories of illegitimate states, there are only states and non-states, intrinsically every state has certain inherent rights. States have inherent rights of self-defense. States have inherent rights to determine their own form of government, to determine their immigration policy, their domestic policy, their foreign policy, etc. Now, there are bounds on the behavior of states in some respects, but written large, the rule is that a state is sovereign over its affairs. So what we have to ask when we ask about the behavior of a state is, within those limited bounds that one has on sovereign states, How can Israel behave and not behave? More importantly is the question of how may a sovereign state be treated. And here because states inherently have certain sovereign rights, there are very important restrictions on the things that other states may do towards states. So, for example, states have inherent rights to defend their sovereignty against encroachments by other states. So, prima facie, an attack on the sovereignty of a state is illegal under international law. When a world leader, a leader of a state, such as Ahmadinejad, declares what appears to be the intent to destroy another sovereign state, that is at least prima facie a violation of Article 2.4 of the UN Charter, which forbids the threat of use of force against other states. So there are important issues to be dealt with regarding the treatment of Israel as if it were an illegitimate state, as if this were a meaningful category, when in fact it's not. Now, that was my conception of the panel. I will allow the panelists to discuss in more detail the questions of the behavior and treatment of sovereign states, and instead I will just take the opportunity to explain to you who our honored guests are. Irit Khan is the distinguished former director of the International Affairs Department, the Israeli Ministry of Justice, and currently a lecturer on international law at the Bar-Ilan University and College of Management's Faculties of Law. She also serves as vice president of the International Association of Jewish Lawyers. During his career, she has been involved in some of the most important international law issues faced by Israel. She led the defense team for former Israeli Prime Minister Ariel Sharon in Belgium when a suit was filed against Mr. Sharon utilizing a theory of universal jurisdiction. She has served as a key player or advisor in Israeli decision-making about the ICJ decision concerning Israel's security barrier and Israel's proposed accession to the Rome Statute concerning the International Criminal Court. Professor Erwin Kotler is a professor of law, international human rights lawyer, counsel to prisoners of conscience, head of an NGO, public intellectual, community leader, and peace activist, a member of the Canadian Parliament since 1999, and former Minister of Justice and Attorney General of Canada. Did I leave anything out? Professor Kotler is a distinguished academic and prominent human rights lawyer whose dedication to humanitarian causes has earned him the Order of Canada among many other awards. Professor Kotler has represented Andrei Sakharov and Anatoly Nathan Sharansky in the Soviet Union, Nelson Mandela in South Africa, Nigerian playwright and Nobel laureate Oz Soyinka, and most recently Saad Eddin Ibrahim, an Egyptian sociologist and democracy advocate. Claims magazine has referred to Kotler as counsel for the oppressed. He headed the Canadian delegation to the Stockholm International Forum on the Prevention of Genocide, initiated the first ever prosecution under the Canadian War Crimes and Crimes Against Humanity Act for incitement to genocide in Rwanda, and he founded the all-party Save Darfur Parliamentary Coalition. He has testified as an expert witness on human rights before parliamentary committees in Canada, the United States, Russia, Sweden, Norway, and of course Israel. Finally, Daniel Taub is the principal deputy legal advisor in Israel's Ministry of Foreign Affairs. His areas of responsibility include counterterrorism, international organizations, and humanitarian law. He has represented Israel at numerous international conferences on human rights and counterterrorism issues, as well as the establishment of the International Criminal Court. He served as Israel's representative at the International Court of Justice during the hearings on Israel's security fence. He has served as a member of the Israeli negotiating teams in negotiations with both Syria and the Palestinians. He has lectured widely on international law and negotiation theory, including at the U.S. State Department, Chatham House, and the Lauterbach Center for International Law, and he regularly...
First of all, to explain it, after that, I would like to tell you what is the explanation for the fact that in the 1990s it started flourishing the way it is perceived today, and thirdly, what is the link or the association with the State of Israel? What is the threat that is perceived today in the State of Israel? Universal jurisdiction is that any country can promulgate a law and try a person is not necessarily linked to it. If a person committed an offense outside that country, is not a citizen or a resident, that country, after it has taken the authority in its internal legislation to put him on trial. When we talk about such a possibility, so what are we talking about? What kind of laws are we referring to? Normally, we talk about three types of crimes: war crimes, crimes against humanity, and genocide. The crime of genocide, those are crimes that are called heinous crimes. The international community agrees that those crimes are so flagrant and are so severe that a person should be tried no matter anywhere, as long as he's nabbed and he's persecuted. The essence of those crimes stem from historical processes. For example, the Nuremberg trials. The convention that based the Nazi war criminals, people who are indicted of war crimes and crimes against humanity that were perpetrated in the Second World War, should be adjudicated before an international military court, which is associated by the signatory, which was England, France, the Soviet Union, the United States, that will operate in Nuremberg. It was equally stated that those criminals can be tried even in countries that set up the said court. The convention was ratified by 19 other countries in 1946. Its principles were adopted unanimously by the UN General Assembly. It was resolved at the time that crimes against peace, war crimes, and crimes against humanity are crimes in all those countries, and each country can prosecute the perpetrators. And indeed, as a result of this step, Nazi war criminals were tried in a number of countries, as was mentioned, including the State of Israel. Eichmann was tried, but there was a great association because the victims lived in the State of Israel. This needs to be accounted as opposed to what I'm going to talk about later on. Another example that I would like to highlight and show you is that the universal jurisdiction had existed before that, and before it broke out in such a serious manner in the 90s, the war laws that were expanded in 1949 by 4 Geneva conventions. Those conventions said what is permissible and what is not permissible during the wars, and talk about regular violations or flagrant violations with regard to the interdictions, with regard to the fact that the country should look for the perpetrators and try them, even if did not perpetrate the crime in that country, did not refer to it and are not its citizens. The description of those flagrant violations expand the definition of war crimes beyond the Nuremberg trial, and in fact subjects them before the universal jurisdiction. And those examples that I've just cited and many others that I cannot go into due to the brevity of time tell us that universal jurisdiction existed before the 90s as well, at which time there was a series of prosecutions that started in many countries and continues today. Henry Kissinger talks in an article which he wrote in 2001 that within 10 years, we have witnessed that an unprecedented movement has organized in order to shift international politics into legal procedures, and he's not the only one to make this claim. This has expanded rapidly, and there was no public discussion about it because of the proponents wanted to try the violators of human rights and the perpetrators of other crimes that were mentioned theoretically. When we talk about war crimes or crimes against humanity, this is certainly a worthy cause to try people when they committed those crimes. But the way it is done, when you talk about the universal jurisdiction in those countries, it has many pitfalls. What is important to stress, although there were conventions that determined universal jurisdiction, we did not see such activity in those countries until the 90s. So how this universal jurisdiction burst in the 90s? We need to bear in mind that through the UN Security Council during the 90s, there were 2 tribunals that were set up that wanted to try crimes in certain areas and during certain periods. I'm talking about Yugoslavia and Rwanda. There were a few other tribunals, but they were set up when the international community thought that such crimes are committed in those areas, that the perpetrators should be tried. Therefore, the Security Council, based on its jurisdiction, set up those tribunals. In addition, we also saw great activity from 1948 in the Rome Convention. In the Rome Convention, when they talked about the law of evidence, namely how to bring single people to try them, it was intimated that it would be highly desirable that other countries would prosecute such criminals. Why? Because the jurisdiction, according to the Rome Convention, was given only to the countries that were ratified it. And we know that many countries did not ratify the Rome Convention. For example, the State of Israel. For example, the United States. For example, Russia. And many other forces that also sit on the Security Councils. That's why the world said, hold on, we cannot prosecute those people, and we cannot try them. And it is very important that people who do have universal jurisdiction would be able to exercise them against those people. The affair owing to which, by the way, and when this trend began of the violation of human rights, the snowball started rolling. And we know when the cannons are firing, the mules are not silent. And then they started saying to build the cases that should be prosecuted in various countries. I would like to relate very briefly to the Pinochet affair. If you recall, it started in 1988. When an extradition order was submitted to England to extradite Pinochet to Spain, the red light has been turned on. From today on, we will start waiting for prosecutions against officers of the State of Israel. It was not long before this happened. So what happened in the Pinochet affair? And I want to examine it, and I want to look at the problems of universal jurisdiction. A Spanish judge wanted to bring Pinochet to England so that he would be tried for violations that were perpetrated against Spanish people in Chile. If we look at what happened historically, we know that Pinochet seized power in Chile, brought about a coup against Allende, somebody who was legally elected to be the governor of Chile. What is interesting to recall, however, that many of the democratic parties at that time in Chile were very happy about this coup, because Allende, when he ruled Chile, he was like a Cuban leader. He used the Cuban weaponry. He was not a dictator because he was elected, but he used dictatorial or tyrannical methods, and therefore people did not regret it. But what happened when the junta started operating the way it did, and they went overboard, people started talking about those crimes.
The critics say that if the Spanish judge would have been a little bit more sensitive and would remember in Spain the regime of Franco, that after the post-administration of Franco, they gave a national amnesty for bringing criminals to trial in order to stabilize the democratic regime, then perhaps he would not have submitted the extradition demand from England and would enable Chile to cope with that problem in the same way. And in fact, I would like to remind you that in 2000, the Chilean court removed the immunity of Pinochet, wanted to try him as possible in that state for the crimes he committed. In other words, I'd like to show you the complexity which is dangerous in the universal authority that is given to any state for being a state, no matter how it tries, what are the evidence laws there, in order to try people who have no connection to it, when it is possible that at the same time we are shutting one eye regarding activities of amnesty or pardon process before you come to some sort of a solution. It's interesting to note at the moment, although it's not universal authority, but in the criminal international law court, when you try in Uganda the heads of the rebels, and Uganda keeps going back to the international court, says not to try him, because there's a reconciliation process in Uganda. They want to let Uganda to deal with its own affairs. In other words, if we talk about processes of reconciliation in states, this universal authority, where a person comes from another country, it doesn't consider these processes, and that can be very dangerous. I'd like to remind you, for example, the court case against Sharon, which is a completely different thing, and I was involved in that. And actually, at that time, I got letters from people who said that they're ready to testify of the activities of Belgium in Congo. Namely, when we bring a person to trial in some state, there's no discourse in the international community what kind of a state it is. And many states that today are democratic have a very dubious past regarding the crimes that they committed at the time. So this is another point that we have to mention when we talk about a universal authority. So if that's the case, that I have another 2 minutes, then let me skip a large part and let me come to the state of Israel. What is happening today, we see that there's a wave of submitting lawsuits against people or our officers in the IDF. I don't have to remind you, we had the issue of Almog, who sat in a plane in Britain. We had an issue of Mofaz and also Dichter of the Shabak. All these decisions are by NGOs that see in Israel a state that violates consistently the laws of war, and it's actually accused of genocide against the Palestinians, things that you can't even fathom, that these are things that there was an intention towards when the laws were actually consolidated. And the danger is that such lawsuits, first of all, they limit the possibilities of people here that they are in war. Of course, if we talk about the wish to commit actions, I don't even war crimes, it doesn't even come into question. But these lawsuits are submitted to courts. Sometimes they have a political agenda because they have a certain attitude against Israel, or courts that have no international skills whatsoever. And the great danger is that there's like this downhill. These lawsuits are going to accumulate, and we know that the difficulty is altogether to see what the results are going to be. Now, the difficulty is very great to fight against these lawsuits. What can you do? Because we know that in democratic countries there's an operating authority and there's a judicial authority. So Israel asking Britain not to do so has no significance, because the executive branch in England has nothing to do with it. What you can do, you try to have an influence on the various countries to limit or to reduce the universal authority and to create a difference between the people who are indicted and the crimes. Otherwise, we go to a place which is very, very dangerous. Today, we're in a world of human rights, and we want to protect human rights, but we have to do it in a way which is balanced. The way that is dealt today in the universal authority, it's not balanced, and it is a danger, and it also serves as a fighting tool against the state of Israel. I'm sorry I have to stop here, but that's the time I'm allotted. Thank you.
I just want to remind everyone, while Professor Cutler is taking the stage, that those who have questions, please write them down and pass them to the front. I'm not sure if we'll have time for questions, given the schedule of former Prime Minister Netanyahu, but if we do, it would be helpful to have them here as soon as you formulate them.
We are witnessing, and have been witnessing for some time now, an ongoing, escalating delegitimization and demonization of Israel and the Jewish people under the cover of law. Indeed, an Orwellian inversion of law, language, and morality, invoking the imprimatur of international law, proceeding under the banner of human rights, and clothing itself under the protective cover of the United Nations. In a word, what we are witnessing is the laundering of the delegitimization and demonization of Israel under the cloak of law, legality, and legitimacy. This is what gives it its sophistication. It is a kind of dialectic where the very delegitimization of Israel actually clothes itself in the aura of international law, human rights, and the United Nations. And so it is then that in a world in which human rights has emerged, as it has been called, the new secular religion of our time, the portrayal of Israel as a meta-human rights violator, as the international human rights violator, results in Israel being seen as the new Antichrist of our time, a characterization that is underpinned by the invocation of both international law and the protective cover of the UN. One caveat to all my remarks. It may not be necessary to say this, but I have learned that it is necessary to say this. And it is this. Israel, like any other state, is responsible for any violations of human rights and humanitarian law. The Jewish people are not entitled to any particular preference or privilege before the law because of the Holocaust or the history of Jewish suffering. But the problem is not that anyone would seek that Israel be above the law. The problem is that Israel is being systematically denied equality before the law in the international arena. Not that human rights standards should be applied to Israel, which they must be, but that these standards are not being applied equally to everyone else. Not that Israel must respect human rights, which she must, but that the basic rights of Israel deserve equal respect. And so what I would like to do at this point is just share with you briefly 4 case studies of the delegitimization and demonization of Israel under the cover of law. The first is the delegitimization of Israel through the singling out of Israel for differential and discriminatory treatment at the United Nations Council for Human Rights. Before you instinctively say shmum, one should know that the United Nations Council of Human Rights decision-making, which replaced the discredited UN Human Rights Commission, is otherwise held out as the repository of standard setting in international human rights law and the sanctioning framework with respect to holding human rights violators to account. And what one finds here is that the effect, if not the intent, of the decision-making at the UN Human Rights Council has resulted in Israel being portrayed as an international pariah, beyond the pale with respect to international law, with all the attending followed for the perceived legitimacy of Israel. Let me give you some examples here. In the first 20 months of its operations, the United Nations Human Rights Council adopted 16 resolutions of condemnation. All 16 indicted one member state of the international community, namely Israel. The major human rights violators, Sudan, Iran, China, not one resolution against any of the major human rights violators, who continued to enjoy this exculpatory immunity while Israel was being denied fundamental international due process and equality before the law. I'm using juridical human rights language intentionally in order to identify the manner in which delegitimization is laundered under the framework of human rights and international law. A dramatic example of this prejudicial singling out of Israel for differential and discriminatory treatment is that on the agenda of the UN Human Rights Council is a permanent agenda item on every meeting of the UN Human Rights Council devoted entirely to Israel. And so if you come to the UN Human Rights Council, as I did, you will find item 8 says violations by Israel of human rights in the occupied territories, and item 9 says violations in the rest of the world. And the UN Human Rights Council never proceeds beyond item 8 namely the violations of Israel. As I'm speaking to you today, before the UN Human Rights Council are 3 more resolutions of indictment. Today, indicting Israel for war crimes, for crimes against humanity, for a collective punishment and the like in Gaza, with, of course, no reference to context, to Sderot and the like, as if even that reference would have otherwise justified it in any case. At the same time, there is a permanent rapporteur at the United Nations Human Rights Council with respect to Israeli violations of Palestinian human rights, which does not include in its mandate any reference to terrorism against Israel, and where today they will be voting on the replacement for John Dugard, who was the special rapporteur and who characterized Israel as an apartheid state, and the nominee to replace him today has in fact engaged in analogizing what Israel is doing to the crimes of the Holocaust. So this is the kind of frame that is occurring as I'm speaking to you today before the UN Human Rights Council. Let me just give you one example, and in most of these things I'm drawing on, personal experience as well. One example of this kind of delegitimization under the cover of international law. I was called 15 months ago by Louise Arbour, the UN Commissioner of Human Rights. She asked me if I would join a 2-person fact-finding commission of inquiry set up by the UN Human Rights Council, which was going to Beit Hanun. You recall the tragedy in which 18 Palestinians were killed in Beit Hanun following the rocketing of Sderot and Israel's response. She told me that Bishop Tutu would be one member of this commission and invited me to be the second. I said to her, Louise, is this fact-finding commission of inquiry going to Sderot? She said, no, it's going only to Beit Hanun. But if you'll be there, you could give it some sense of balance. I said, I've looked at the resolution of the UN Human Rights Council establishing this fact-finding commission of inquiry. And that resolution, before the fact-finding commission even undertakes its investigation, has already condemned Israel for war crimes, for the wanton killing of women and children in violation of international law. It's in the very terms of reference of the United Nations Human Rights Council resolution establishing that commission. And so, as I said to her, I would not be a fig leaf with regard to that commission. And I went to the UN Human Rights Council last June and shared with them exactly what I'm sharing with you as a case study of the delegitimization of Israel, invoking the imprimatur of international law and the protective cover of the United Nations. Which brings me to the second case study, and I'll move more quickly. I'm referring here to the annual ritual of resolutions at the United Nations General Assembly, where anywhere from 19 to 21 or 22 resolutions are passed every year at the United Nations General Assembly in a 3-month ritual of delegitimization from September to November, where the 19 to 21 resolutions exceed all the combined resolutions passed against all the other 190 members of the international community. Again, a flagrant denial not only of international due process to Israel, but providing exculpatory immunity to the human rights violators. Let me just deal with 2 of many, many examples that have come under the rubric of the UN General Assembly because of the particular followed. The first example is that the United Nations General Assembly has adopted some 850 resolutions dealing with the Middle East. When Trevor Ashton gave you the breakdown with regard to the BBC, 80%, 20%, you can find the same kind of preponderant indictment of Israel at the United Nations General Assembly. But with respect to those resolutions, there have been over 130 resolutions that have dealt with Palestinian refugees, but only with Palestinian refugees. As I speak to you, there has not yet been one resolution that has addressed the question of Jewish refugees from Arab countries. And so what you have in terms of the United Nations General Assembly and the UN system as a whole is the expunging, the eclipsing of Jewish refugees from Arab countries from the international peace and justice agenda these past 60 years since the partition resolution of November 29, 1947, thereby not only distorting the narrative of the Middle East, but contributing to the ongoing delegitimization of Israel. And yet again, this year, November 29th, the United Nations once again had its International Day of Solidarity with the Palestinian people. I have no problem with an International Day of Solidarity with the Palestinian people. I have a problem when there's never a day of solidarity with the Jewish people. On the contrary, the expunging of the Jewish people from the map of the Middle East. Which leads me to the second example that I wanted to give regarding the UN General Assembly. And Avi Bell has written on this. And that is the International Court of Justice advisory opinion on the security fence. During the period I was Minister of Justice, the issue of the International Court of Justice being seized of the issue of the security fence arose. And as Minister of Justice in Canada, I gave the opinion that, in my view, the International Court of Justice did not have jurisdiction in this matter. And it did not have jurisdiction because the United Nations General Assembly, referring the issue to the International Court of Justice, had already predetermined its outcome. And so it was a seriously flawed resolution in which, once again, Israel could not have a fair hearing before the International Court of Justice. And this brings me to the third case study, and that is the laundering of delegitimization under the banner of the struggle against racism, which takes on its own particular sophistication, because who does not want to be anti-racist? And so the invitation, therefore, is to invite the international community to be part of the international struggle against racism. Durban metaphor and message for this. And then this struggle turns out to be one against the apartheid Nazi state of Israel. Nor are those two epithets chosen accidentally. They are chosen because they ascribe to Israel the two great evils of the 20th century, which are defined as crimes against humanity in international law, thereby serving as a warrant for the delegitimization of Israel in that regard, and a message that it is necessary, because Israel is a Nazi apartheid state, to bring about its dissolution, because Nazi apartheid states do not have any right to exist under international law, having been pronounced as a crime against humanity. The fourth and final case study, and which interestingly enough invokes the first three case studies that I mentioned as prologue and justification, is that of the teaching of contempt and the demonizing of the other that finds expression in the state-sanctioned incitement to genocide, whose epicenter today is Ahmadinejad's Iran. Now, one would have thought that the open, public, state-sanctioned incitement to genocide in Ahmadinejad's Iran would be utterly without, and unlike the other three case studies, utterly without any cover of law, without any UN protective cover, that it would constitute the ultimate assault on the UN Charter and the violation in the Genocide Convention, in the Treaty for an International Criminal Court, which prohibits, for example, in Article 3 of the Genocide Convention, the direct and public incitement to genocide. That this, therefore, would result in the international community and states in the international community, particularly those that are state parties to the Genocide Convention, with the responsibility to enforce that Genocide Convention, that they would invoke the panoply of remedies under the UN Charter and the Genocide Convention to hold Ahmadinejad to account. On the contrary, Ahmadinejad's visit to the United Nations, to the United States, and to Columbia University was a case study of the theater of the absurd, where his visit was itself legitimated under the rule of law, rather than it being serving as a case study of the disregard of the rule of law. Very quickly, three examples. Ahmadinejad should have been excluded as an inadmissible person to the United States under American law, under domestic American law, which excludes from entry into the United States any person who has incited to terrorism, etc. In fact, when it was said to me, well, you can't do it, it's a president of a state, we forget that Waldheim was excluded from the United States precisely under this domestic application of law while he was serving as a president. Moreover, Ahmadinejad should never have been given a podium at Columbia University, which was justified under the notion of academic freedom and free speech. No academic freedom can justify giving a podium to those who incite to genocide. But more importantly, the Genocide Convention prohibits the direct and public incitement to genocide. In other words, state-sanctioned incitement to genocide is prohibited speech, not protected speech. And Colombia's role in that regard should have been clear. And a third component was with respect to Ahmadinejad appearing at the United Nations General Assembly. Ahmadinejad should not have been a welcome guest at the UN General Assembly. He should have been an object of a criminal indictment. As I put it elsewhere, and we'll quote from this and move therefore to a close as I wrote, a person who incites to genocide, who is complicit in crimes against humanity, who continues the pursuit of the most destructive of weaponry in violation of UN Security Council resolutions, who also warns Muslims who support Israel that they will burn in the Ummah of Islam, who's engaged in a massive repression of human rights in Iran, who assaults the basic tenets of the UN Charter. Such a person belongs in the dock of the accused rather than at the podium of the United Nations General Assembly. And so I just want to close by saying that my entire theme has been here, the laundering of delegitimization under the cover of international law, human rights, and the United Nations. The time has come not just to lament what is happening, but indeed to sound the alarm. Not only to sound the alarm, but to act. And when we act, we're not acting only with respect to Israel. We're acting in terms of the protection of international peace and security. We're acting in terms of the assault that we are witnessing on international law, on human rights, on the UN Charter, on fidelity to the rule of law, on the culture of accountability. It's time to restore fidelity to the rule of law and to end the culture of impunity.
Good afternoon. I hope at this point in the day, it's fair to assume that there's two working assumptions that we can agree on. The first one, that there is unfortunately a deep and concerted campaign of delegitimization against Israel. There is somehow some sort of magnetic force field in our part of the world that seems to pervert the world's moral compass. And the second, particularly from what we've already heard this session, that this campaign has a strong and worrying legal aspect, both in an attempt to establish legal principles that can be used as a campaign against Israel, and to harness international institutions as part of that campaign. And I think, as Professor Kotler warned us, that it's not just the fact that this is also escalating. If we take a step backwards, we can see that maybe 40 years ago, most of the attempts to delegitimize Israel were limited to the political fora of the international community. For example, the famous Vote Zionism is Racism in the General Assembly of the United Nations. In the decades that followed that, during the 80s and 90s, we saw a deliberate attempt, primarily by the Arab group, to expand the circle of influence of the automatic majority to the humanitarian and human rights organizations, institutions within the international community, including some of the shocking abuses that Professor Kotler was talking about in the Commission of Human Rights, and culminating at the end of the 1990s in the Durban Conference. And if we had to characterize the last 2 decades, I think they could be characterized by an attempt to expand this circle of influence still further to a third arena. And that's the arena of the legal and judicial institutions of the international community. And it's there that we have seen the gross politicization, unfortunately, of the International Criminal Court, with the inclusion of crimes deliberately targeted to target Israel. We've seen the referral of the issue of Israel's security threats to the International Court of Justice. We've seen the abuses of universal jurisdiction that Eric Carr was talking about. And this expansion to the international legal arena means a number of things for Israel. First of all, it means that unfortunately Israel is frequently deprived of the opportunity to do the right thing. I have to say one of the saddest moments of my professional career was being at the conference where the statute of the International Criminal Court, this permanent war crimes tribunal, was adopted, and hearing the head of our delegation, Judge Eli Natan, an Israeli judge, a great humanitarian and a Holocaust survivor, explaining why Israel could not ratify the statute of the court. And the other thing that it means for Israel is that we frequently find ourselves in a complex dilemma of to what extent we should participate with the organizations that have become instrumentalized. And to a great extent, it's a tension between influence and legitimacy. On the one hand, we might be able to influence the outcome. On the other hand, the moment that we begin to do that, we inherently give more legitimacy to the institution that we're troubled about. But the main thing that I wanted to think about with you was the question of why it is that international law and international legal institutions have become a more convenient forum for anti-Israel campaigning. And I think I'd like to just focus briefly on three developments in international law that seem to make it a more convenient forum. The first is quite simply the speed with which international law develops. It used to be that to develop a treaty or to develop a principle of customary international law was a long and painstaking process. Today, partly because of globalization, partly because of new threats, it's a much faster process, but it's also because the international community has developed a number of rather worrying shortcuts. I could speak about it at great length, but I'll just point out a major work that was published by the International Committee of the Red Cross, a 3-volume encyclopedia of what they call customary international law. This is supposed to be principles of law that is binding on you whether you're party to a treaty or not. And there are all sorts of shortcuts which have been very troubling and attracted a fair amount of criticism from legal advisors in the United States and in Britain. The reliance on really not on what states do as examples of state practice, but on what states say they would do. For example, in military manuals and so on and so forth. The second change, I think, in the nature of international law is a change in the nature of players. International law, when it was established, was clearly seen as being the rules governing relations between states. But when we look at international arena today, we're talking about players which include many, many kinds of non-state actors. Why has this happened? Well, I think one way of thinking about this is to see it as a result of a gradual change in the attitudes of states from an effectiveness paradigm to an entitlement paradigm. It used to be that if you wanted to be regarded as a state, you used to have to bully your way onto the international arena. What happened, really starting from the Treaty of Versailles and developing onwards from then, the international community said we have now principles of self-determination and so on. They would say to peoples, you have the right to be a state, we will give you the capacity. But unfortunately, the international community frequently didn't follow through on its promise, and we found ourselves with a capacity deficit between entitlement and capacity. And really what was created was what Michael Reisman of Yale calls an undertow, a sort of vacuum that has drawn new actors into the international arena. And they're actors of different sorts, including, for example, non-governmental organizations that we heard a lot about from Gerald Steinberg. Very, very troubling because of the power that they have, which in many ways is far greater than the power of states. They don't have checks and balances. They're not worried about reciprocity. They can be extremely single-minded. Even though they can be funded by interested individuals, they carry with them this aura of democracy. And we're talking about, according to UN statistics, some 30,000 international NGOs, and obviously a far greater number of NGOs, domestic NGOs. And they've had dramatic effects on the development of international law in areas like mines, environment, and so on and so forth. International organizations are another new actor. In theory, an international organization is simply a technique established by a treaty for allocating responsibilities between states. But over time, international organizations have developed their own identity, have developed their own agenda, and developed their own survival mechanisms. And also we see multilateral corporations are also new agendas on the international arena. When Bill Gates is greeted like a head of state when he visits another country, to a great degree, that's rightly so. He is heading a corporation whose monthly turnover is equal to the GNP, annual GNP of many states. I mean, there's a test called the Skyline test. In 1800, if you looked at any city in Europe, you would find that the tallest buildings would probably have been religious buildings, the churches. In 1900, if you looked at the tallest buildings, those would probably have been governmental buildings. Today, if you look at the tallest and most impressive buildings, they don't belong to religion, they don't belong to government, but they are actually populated by multilateral corporations. And that is a sort of reflection of the changing nature of power in the international community. What all these new actors have in common is that they are all actors in the creation of international law, but they are not themselves bound by international law, because international law remains the type of law that is binding on states. And the final development that I'll mention is the whole question of enforcement. It used to be that international law was questioned, is it really law? It doesn't have teeth, it's not enforceable. Today, increasingly, we find bodies of international law that have stronger verification mechanisms, arbitration mechanisms, sanctioning mechanisms, and so on and so forth. And also, this ties in with the point that Irid was making. We find that in addition to all these other new actors, we have individuals who have become new actors on the international plane, both as having standing, for example, before human rights courts and tribunals, and having individual criminal responsibility, for example, in the situation of the ICC and universal jurisdiction that Irid was talking about. What all of these things mean, in short, is that from having been a fairly cumbersome, state-centered, non-enforceable body of law, international law has increasingly become a fast, flexible, non-state-guided body of law with the potential of creating binding or enforceable results, which obviously make it attractive as a tool in a campaign against Israel. So what do we do? How do we navigate ourselves in this new environment? I would suggest that we have to turn the tables. If people are using law to question the legitimacy of Israel, when legal principles are used against us, we have to question the legitimacy of those principles. And basically there's 5 questions that I think that we have to ask. The first one is it law? There are certain things that are cited as law which quite simply are not law. A General Assembly resolution is not law. Other assertions that are made. 2 weeks ago, during the fighting in Gaza, the European Union presidency issued the following statement. It called on Israel to refrain from all activities that endanger civilians. Such activities are contrary to international law. I know of no principle of international law that says when missiles are firing from you, from the heart of populated areas, you can take no measures against them whatsoever. The question is, what is a lawful response? What is a proportionate response? We have to ask ourselves, is it law? The second question is, not is it law, but is it lawful? And I think the point here is a point that Erwin was making and others also made, is that frequently the attempts to delegitimize Israel are themselves not legitimate. And I think the referral of the security fence to the International Court of Justice in The Hague, which trampled all sorts of procedural requirements, is a striking example. I'll mention just one of them. The Palestinians were given the right to appear before the court, even though they are not a state, and the statute of the court requires that only states appear before the court. And yet, in the judgment, in the advisory opinion of the court, it was found that terrorism that came out of Palestinian areas did not give Israel a right of self-defense under the Charter because it did not come from the territory of a state. Now think about that double think. On the one hand, they were a state enough to appear, but they were not a state enough for terrorism to give rise to the right of self-defense. Thirdly, I think we have to ask, is it universal? Clearly, justice selectively applied is justice denied. There are countless examples. I'll just mention that I've had the very dubious honor of participating twice in meetings of all of the parties to the Geneva Conventions to condemn Israel for non-application de jure, non-formal application of the principles of the Geneva Convention in occupied territory. And it's remarkable because, to the best of my knowledge, the practical application of those provisions by Israel is, with the exception of the campaign in Iraq, the only time that they have ever been applied by anyone in the history of the Convention. So again, selective application clearly undermines international law. Is it impartial? Clearly, often the arbiters, or the so-called arbiters of international law, have their own interest. I have examples, but I think I'll skip them at another opportunity. I'll happily engage in them, because I think the most important question is the last question, and is, does the presentation of international law correspond to reality? Last week I had sitting with me a very eminent group of jurists who had come from some body examining Israel's compliance with international law, and obviously they had many great doubts. And at some point during the meeting I said to them, tell me, you are an eminent group of jurists, you visit conflict situations throughout the world. Tell me, looking at the situation in Gaza, what would you say is a lawful and proportionate response? What is Israel allowed to do in these circumstances? I was met with a full minute's silence, after which the chairman of the group said, well, that of course is an acontextual question. I tried to give it some context, but I simply wasn't able, and there was simply no answer. I think, just to conclude, I will make two final comments. The first thing that I think it's very important to remember is that our enemy is not international law. Our enemy is the abuse of international law. And a situation without international law is clearly worse. The chaos that would result is clearly worse. We have to remember that not all developments in international law are negative from Israel's point of view. There are areas of international law that are developing even positively as far as Israel's interests are concerned, for example, in relation to cultural property and so on. And there are other areas which are uncomfortable for us, but I think we have to recognize that for all of that, it's the right thing. If there are developments in the field of trafficking in persons or monitoring laundry, and we're falling behind the standards, that's not necessarily a problem with international law. It's frequently a problem with us, and we have to put our own house in order. And the last point that I would make is this. International law can change, and we can actually play a role in changing it. Under the statute of the International Court of Justice, one of the sources, the established sources of international law, is opinio juris, is the writing of legal experts and so on and so forth. And so, to a very great degree, we actually have the international law we deserve. And I'd like to pay tribute here to the new program headed by Dr. Bell in the JCPA, actually following developments and, in a sense, seeking to affect developments in terms of the development of international law. And I think it's something that beholds us all to be a part of. Thank you very much.
I understand that we have about 2 minutes until our next distinguished guest arrives, unless I'm mistaken. So I will now present a question to Professor Kotler. If there's time before he arrives, I'll present another one. Professor Kotler, how do you respond to charges of the illegitimacy of the State of Israel on the basis of it being a so-called apartheid state?
The first thing I say, and I remember just anecdotally, and I hope that'll respond, some 22 years ago I was here meeting with a number of colleagues, and they were referring to Israel as being, an apartheid state. And I looked around in the room and I said, I don't recognize anyone here from the real struggle against apartheid in South Africa at the time. And I said, if you say that Israel is an apartheid state like South Africa, that means that South Africa has a free press, that it has a universal franchise, that it has an independent judiciary and the like. In other words, it undermined the struggle against apartheid. And the same thing today. If you refer to Israel as an apartheid state, then what you are doing thereby is undermining the whole struggle against racism. Because if you say that Israel is an apartheid state, then nobody it can be called an apartheid state in the sense that they are engaged in racism. In fact, the real apartheid, and I think we should turn it around, the real apartheid is the refusal to accept the legitimacy of a Jewish state in any borders in the Middle East. That's what the real apartheid is, and that's what we should be focusing on.